All right, good afternoon, everyone. This is Kurt Barone, and welcome to another edition of Fire Law Roundup, this one for April 4th of 2022. And Brad, why don't you kick us off, and I'll deal with this. There we go. Go ahead.
Sure. Yeah, we're going to try to keep this to 30 minutes or 45 minutes, right? Shouldn't be too bad. But I got to tell you, this week, I really want to say, we do a nice job, I think, of summarizing the cases and what has happened. But I got to say, especially with one you're going to talk about, Palm Beach, and a couple others, people should read these and digest these because there's some really critical stuff in this week. And I wish we had 6 hours. But let's get a couple out of the way, and I'll do my best to summarize some very complex facts. But let's talk about Leduc, city of Leduc, which I believe is Ontario, Canada, Alberta.
Yes. Yep.
And there it's kind of easy, but I want to reiterate some of the things that happened, just as if you're doing this, don't type of point. So really the only news, which was short, is 2 more people resigned. The chief had resigned, on kind of questionable why, whether it's related or unrelated. But in any event, 2 female firefighters had filed a suit alleging they were exposed to systematic harassment, bullying, and discrimination. And I just want to be clear when you go back and see what some of those things were. So let me just tell you, because if you're doing these things, and again, allegations, but if you're doing what she alleges, don't. So a female firefighter alleged that when she joined almost immediately, when she was hired this goes back 20 years in 2002, she says a male colleague exposed his genitals to her, and she faced inappropriate sexual advances and groping. And a male firefighter climbed into bed with her while she was sleeping in the dorms. So look, I can see the other side to this, that, oh, she got along great and we knew her and she was good with this, but I don't care. Don't. Just don't do any of this, because what starts maybe as, I thought, we were all joking with each other, ends with, I didn't think it was funny. And just don't. So, she would talk about that she's claimed that she was on engine shifts. And in her annual review with the captain, she was told, watch your back. You got a target on your back and watch yourself. And so she believed, she was being involved in a lot of discriminatory, harassing, almost or actually assaultive behavior. And what she says, which is important, she said, because of the harassment assaults that I experienced, I was particularly concerned because as a firefighter, I'm involved in a dangerous situation where I have to rely on these people for her safety, and they don't make me feel safe in the station. So people have this, and I'll end this part here. People have this bad habit of saying, oh yeah, we don't get along in the station, but we get along great, on the fire ground when the bell goes off. And that's just not true. That's just not a true statement. So,
Brad, let me throw just a couple, because I don't know anything about Leduc, but what I do know is typically what happens when a female brings an allegation forward. Typically, there's an effort by the part of the male hierarchy in the department to try to say, oh, don't take offense to that. It's just boys being boys, or, oh, it's not that big. I'll have a talk with them. And those types of expressions find their way into federal court lawsuits. Now, this is a Canadian suit, but very often I see those kinds of soft pedaling of the problem and trying to just sort of make the problem go away. It's almost like, we have this protective nature, and it feeds into the problem. So that's one. And sometimes there's a sense that when the people who are doing the harassing are of value to the organization, maybe they're perceived as being some of your better firefighters or the best, or they're the ones that are always showing up when you need them, that there's almost a subliminal, subconscious prioritizing of the males versus maybe the people who are filing the complaints. In this case, it was females. And that is a deadly recipe for making a bad decision that you can't downstream, you can't justify it. I don't know if that had anything to do with this case, but
it's common. It's common. So clearly what you're saying is a common statement from people think, oh, I had one a week and a half ago where we terminated an employee who grabbed the calf of a younger female as she's climbing into the engine or something, and had been making inappropriate comments. And he was at the disciplinary hearing, he was so in shock because he kept saying, well, but I just treated her like one of the guys, as if that's okay. It's not okay to treat someone like one of the guys. You shouldn't treat one of the guys like one of the guys, right?
Yeah, and what happens, what you can get away with even in a nightclub is not what you can get away with in the workplace. So the fact that you might treat someone in a certain way or get away with it in a nightclub or some other party, that is not going to fly in the workplace, you know, and we've got to find a way to clean up our act. That's the bottom line.
Absolutely.
So.
Okay, so if we could, I'd like to jump to because I could summarize this pretty quickly. Talk about Rhode Island, and I don't know if you're anywhere near. I mean, everything in Rhode Island's near each other, I guess.
pretty clear.
Yeah, but a Rhode Island paid firefighter was terminated, and I'm not going to go through all the details because I don't think all of them are important, but I think some of them are important. You might pull out others, but he was terminated, and he claims that, look, I was terminated pretextually, that there was a reason I was terminated. And he claims that he was a whistleblower as to a couple of things that happened at the firehouse. But ultimately, and he was involved in an assault. There's a question who started it. So he sues in federal court. But ultimately, here's what happens. So he claims he had a heart condition or some condition. He agreed, and they had an agreement with the employer that he would undergo an independent medical exam. They did that. The independent medical exam found that his injuries were not work-related that he had claimed he had. He then misses work and runs his sick time out and couldn't return to work. So here, and this is a very common theme across many different types of lawsuits, is the question, was there a non-pretextual reason? I'll explain that. A non-pretextual reason for someone's termination. In other words, was there a non-discriminatory motive for the termination that had nothing to do with anything he claimed? And he claimed he was a whistleblower. He claimed he was assaulted. He claimed he was retaliated against. But in short, the court says, listen, the employer had a valid reason, which was not related to anything else he claimed, that he couldn't return to work. He had undergone an independent medical exam, which he agreed to. It found it had nothing to do with work. And they terminated him because in March 2019, he was out of any leave time and he couldn't report to duty. So his termination was completely non-pretextual, had nothing to do with his whistleblower claim or anything else, and his employer's allowed to terminate him. And the part I want to point out to everybody is, this doesn't appear to be where the employer was trying to cover up things and trying to say, oh, now he's out, let's try to use his sick and illness as a condition of, or a pretextual rule of terminating him. It really looks like the employer had the right motive and the right reasons to terminate someone. So that's what you need when you terminate someone, even if they're, as you would call them, a toxic employee, where they're making other claims and allegations. Here they got lucky, right? The employer got lucky. He couldn't return to work, and they had a good reason to say, I'm sorry, you can't return to work. If you can't return to work, you can't work, you're fired. Hope that does justice to it, but yeah,
I think the court is going to allow it to go back to state court on the state law claims, if I'm not mistaken, or maybe not. I'm not sure. There's a couple of cases where the federal courts have turned down the federal claims. This one, I don't know. So sometimes we cover so many cases that I'm not sure that they sent it back. Looks like they chopped. Go ahead.
Yeah, they did cut it up into different counts.
But it looks like it looks like they did decide the state law claims. I apologize.
Yeah, that's what I thought. So, but what I'm not discussing in here are some of his First Amendment claims. So that's only because I think the last case we should do, so we can spend as much time as we need, is really the Palm Beach case. But he did raise some, issues which were held not to be matters of public concern. That'll make more sense to everybody. So they even dismissed his First Amendment claims. Okay, and the one I found really, really interesting, and again, I really want to leave you a lot of time with the Palm Beach claim, so I don't want to get too lost in it, but is in the city of East Chicago. And here, it's funny. I'm so glad the judge did a really good job. But here's what happened. Basically, there's a mayor who used to be a firefighter who in 2010 became the mayor of Chicago. And he clearly does not get along with the union, and the union and him are going head to head. And at some point, the union's trying to put up a different candidate and it's not supporting them. And so the then mayor did win. Now, normally my advice to somebody, if you win gracefully. If you lose even more gracefully, right? But he won, and then he did something which he did a lot of things, but the key part of this case, he changes their schedule. I've never seen this schedule before, and I was glad because the judge says they couldn't find anyone with this schedule, but they do an 8 hours on, 24 hours off. And as a past chief, I'm thinking, my God, is that expensive? Why
it's punitive. That is an awful schedule.
And that's what the court
terrible.
Held. Right.
Yeah.
And the court held it was dangerous, sleep deprivation, and a lot of other problems. Right. But the legal issue here is they said, look, the government cannot take adverse employment action against an employee, or here every single employee, and well, all the line, not the chiefs, just the line, right, who are coincidentally the ones who are in the union. And the court says the government can't take adverse employment action like this, especially when it's harmful, against employees in retaliation for exercising First Amendment rights to free speech. And they did, and the discussion, the part that was free speech here, is the firefighters are complaining about salary issues and, all these things and work schedules. And they said, look, that's a matter of public concern. You cannot retaliate against them. And the mayor did. I mean, there's a lot more in the facts, but so what the court says is they got a strong likelihood of winning because they engaged in protective First Amendment activity, and that engaging in that activity was a motivating factor in the mayor or the city's imposition of an 8 on, 24 off work schedule. And they suffered a deprivation, which is likely to deter free speech. So my thought on this is to say to employers, if your employees are upset about something you've done and it's a public issue, or they're opposing you in a election, don't retaliate against them. I thought that was pretty clear. I cannot believe the one I want to talk to here is the city's council. They must have a pretty big in-house city council. And who thought this was a good idea? Right. So.
Well, I know a number of elected officials that are really little more than bullies, and they're, like Brad, you own your business, I own my business. If we choose to do something, and we're wrong, we pay for it. An elected official does something like this, they don't pay for it. The taxpayers pay for it. And that's something. And, I think what you have here is a petty elected official, a petty bureaucrat in some respects, using their position, knowing that they're not going to pay for it, that the taxpayers are going to pay for them to go after. And I think back to my own career in dealing with certain elected officials that were really little more than bullies. And doing something because they can. But I got to tell you, hats off to the judge in this case, because I think it would have been very easy for a judge, many of whom went to high school, college, law school, without ever really working a job. They pretty much went right through, and then, at some point they became judges, and never really worked a schedule like that. And I think the judge really kind of kept an open mind about it. I can just imagine some of the judges just rolling their eyes at some of the testimony. And this judge didn't, and he paid attention, and he came out, he realized just how onerous this kind of schedule is. And apparently, that 8 hours on, 24 hours off has been used in other professions. But here's the thing, and he didn't even mention it in the decision. It's been used where people work 40 hours a week.
Right.
Not 53 hours a week. And in this case, these firefighters are working 56 hours a week. So literally you're working every single day, no day off. It's crazy. It is absolutely crazy.
And I don't understand how okay. So in any event, it must have been such a pissing match because this had a cost a fortune, but nonetheless, Okay, so let's go to one which I really think is a big deal for somebody. I'm glad I haven't seen too many cases like this, but I am asked questions about this all the time. So we're going to talk about in Illinois. Let's stay in Illinois, and some Illinois firefighters.
Well, East Chicago was Indiana. That's a curveball. East
Oh yeah,
Chicago,
sorry, damn
believe
it,
it or not,
get
East
it.
Chicago's Indiana. So, but yeah,
Okay,
but go ahead.
so oops. So here, and it's funny because it's the Cicero Fire Department. We have Cicero's right down the street from me. So I was like, oh, not here. So in any event, there's a Black Lives Matter protest. It was in 2020. A lawsuit's filed over it because two paramedics responded to a shooting. An individual shot in the head, and they put the individual on stretcher. His head is bandaged, and then, according to the suit, that one or both of the medics, I don't see how it was either, but one or both of the medics allegedly either actually photographed the body or allowed others to do so. It's that second part, which I think is more likely, not that they allowed others to do so, but that others did so. Nonetheless, the image was then allegedly forwarded to a retired lieutenant, who then posted the photograph with a comment, which was not a great comment, right? But come to Cicero to loot and break shit, get a free body bag, nice headshot, right? And the court went in more detail on this. But here's the interesting thing. So they sued, and I guess on the decedent's behalf, he died. And by the way, this was within like everything was posted within like 2 minutes of their arrival on scene. So the factual question would have been a very tough, road to hoe of what did the paramedics exactly do, because they clearly were treating the person. But nonetheless, here's what the court says, and I think this has widespread importance beyond this incredible set of facts, which is that they said, well, you violated his rights to be private and to have his private medical information kept private. And the judge didn't really take issue with the fact that he's being treated. And yeah, there's some private medical information, right? Even though the complaint didn't do a good job of talking about it, said the judge. But here's what the judge said. This was on a public street during a public protest. It took place in public. Anybody there could have seen it. News cameras could have caught it. So even though this was kind of extreme, it's all in public, and there was nothing private that was disseminated. So they said there's no real violation of his claims of his federal civil rights, because it's all in public. There was nothing that was private. And I thought that we could take that to a lot of
it is, but we got to really dissect this one, because they made some state law invasion of privacy claims and some intentional infliction of emotional distress. They made those claims, but the case was decided on the federal civil rights aspect. And so the court said, look, we're not going to look at the other state law aspects of this. We're just going to look at the federal civil rights, and we see no invasion of privacy or no civil rights violation on the federal side. And that's why they dismissed it. So it's possible there may be some state law claims that survive if the case goes to state court. But I think federally, there was no federal violation.
And I'm assuming because the judge went to great lengths to say, you didn't state this in the complaint. And he kind of goes, even if you had, here's what might happen. But maybe they'll seek to amend the complaint as well and kind of expand the allegations. But I thought it was a great holding of things that happen in the public view, right? Don't necessarily, or probably don't vest you with a privacy right, because it's right in public view. And this happens a lot, right? I mean, think of all the bad. I'm not saying it shouldn't result in termination of a firefighter if they actually photographed it or allowed it, or could have stopped it, I suppose. But this has a lot of implications that, something that happens in public on the question of right of privacy, might not be protected or is not protected.
Yeah, and I think one of the things I think I pull out of this also is that they can't tell who took the picture. There's nothing in there that says the firefighters took the picture. Right. In the event that it was the firefighters that took the picture, I think you got some differences here, okay? But in the absence of proof that the firefighters were the ones that took the picture, or the medics were the ones, I think that the claim is not going to be recognizable under federal law. Maybe there's some state law claims, but the judge wasn't going to entertain those.
Right. And if everybody's sitting here saying, well, what about HIPAA? What about HIPAA? Again, and this is one of the cases that's on your site. I just
HIPAA hysteria.
Yeah, that's right. Right there. But HIPAA doesn't provide a private right of action, meaning you can't sue under HIPAA. It may be used as maybe a standard if I stretch it, but you can't sue under HIPAA. So if you're wondering, well, why not HIPAA? But it's not going to be raised in a private suit, or should be raised on a private suit. Okay, you want to jump to Palm Beach?
Yeah, let's talk about Palm Beach, and we've been following this case since it happened. So,
Great
yeah,
case.
it is, and I think it's important. I do want to say to the folks who've been to my social media class and the policy drafting class, there's nothing in the case that is going to require us to edit the policy. My recommended policy language is perfectly fine under this decision, so there's nothing in there, but if you have a social media policy that has any of the language, and I listed it on the on the decision, such as you prohibit employees from disseminating content that is inconsistent with the duties, conduct, etc., or you tell people that they cannot post things in a manner that shall reflect negatively upon the fire department, and a lot of those other very common terms, you may need to go back, or may need to at least, have your attorneys go back and look at that language in light of this case. But let's talk about the case. We had a union election back in 2018, and one of the plaintiffs, A.J. O'Loughlin, was running for president, I believe. And he had made a comment. He had criticized one of the other people that were, I don't know if he was running also, or he was an elected member. At any rate, he criticized the use of union time off over Thanksgiving and Christmas. Apparently, as part of their agreement with the city, the union had built up a bank of time off that union officials could use if they had to go for a grievance or an arbitration or whatever, negotiations, whatever it would be. That would be sort of the understanding. Well, apparently, the allegation was that one of the union elected officials had used the time for to basically take some time off over the holidays. And so, as part of his campaign, he posted on Facebook that, and it was a private group, chat group on Facebook. So it wasn't on Facebook public, but it was basically critical of the union's allowance of this time off under the circumstances. So that was Captain O.J. O'Loughlin who posted that. Captain Crystal Little agreed, and she commented also in a way that was kind of negative toward the way that the time off had been granted. And both of the captains were disciplined by the department for their social media comments, and they sued. And I don't think they got it doesn't seem like that they got a very serious discipline. I think it was just a reprimand, as best I can tell. But they said, no, we have a First Amendment right, to say this. And the district court, which, going back to my comments about the judge in the East Chicago case, I think the judge in this case, the original judge, the trial judge, went the other way and just said, there's no First Amendment issue here. It's not a matter of public concern. And it was to a private group on Facebook. Therefore, there's no First Amendment issues here. And didn't really understand what was going on here. So the trial court dismissed it. The case was appealed up to the 11th Circuit. And the 11th Circuit, in I think a very well-reasoned decision, said, wait a minute, this is a matter of public concern. There's allegations here. And for those of you who aren't familiar with, how we approach First Amendment issues in social media, we use the Pickering balancing test. So it has to be a matter of public concern, posted in your capacity as a private citizen, not in your capacity as a public employee. And then we get into a thing called the Pickering balancing test, and so on. So the trial court ended the inquiry at the first question, which was, is this a matter of public concern? And the 11th Circuit said, hold on, this is a matter of public concern. It involves an allegation of improprieties. The fact that it's sort of internal to the fire department, internal to the union, doesn't change the nature of it to be not a matter of public concern. It is a matter of public concern. And now the case has got to go back to the trial court again to do the rest of the Pickering balancing test analysis. In addition, the 11th Circuit also looked at the constitutionality of the social media policy and whether or not it infringed on protected activity. And the court concluded that it in fact did. And we can take some quotes. Let me just read you some of the quotes. Let's see. The social media policy suffers from the same sort of astonishing breadth. Okay, and what that means is the scope of what types of speech is suppressed by the policy. So the same sort
examples, right? I like his note that's saying examples don't limit it at all.
Right. And astonishing breadth that was struck down in one of the leading cases, Liverman versus St. Petersburg. And this is a case out of Virginia that involved police officers. It could, you know what, the funny thing about Peterman, it could just as easily have been a fire case because it was police officers complaining that the department was promoting people too quickly before they had really gotten enough field experience. So it could have been firefighters saying the same thing, but it was police officers. And the Fourth Circuit in that case, in a very important and well-reasoned decision, said that kind of speech is protected, and the police department's social media policy it suppressed protected speech. Okay, so here, getting back to the to the Palm Beach County case, their policy expressly prohibits disseminating content that could be reasonably interpreted as having an adverse effect upon fire rescue morale, discipline operations, the safety of staff, or perception of the public. In the Liverman court's words, that could be just about anything. I mean, so if you post just about anything, you're at risk of being disciplined. And so you can read some more of the language in there. I can tell you, I'm going to be incorporating this case into my classes on social media because I think it's that important. It's going to go right alongside Liverman. Yeah. So, but Brad, you know, this is one area that I focus on, but what, from taking a step back here, how, you know, where you come down on this ruling?
Well, I love the ruling. I do. I think it's right, and it's actually clear and understandable, which a lot of these Pickering decisions are not. But there's other parts that I think we should also highlight. You know, here they were on Facebook, right? And it was a invitation only group on Facebook. And the Supreme Court, you know, they said, well, they rejected the proposition that private expression of one's views is beyond constitutional protection. And you know, the private expression of one's views is not beyond constitutional protection, right? And the court held that, you know, even in a closed Facebook group with, I think there were a lot of people on this group, right? That
well, it's a pretty good sized department, so I would bet they had quite a few people on there. Maybe not the public, but.
And so the fact that they aired their grievances right before a union election or a run-up union election or whatever, this is still a public online platform, even though it's only with, you know, friends, so to speak. So if people are thinking, well, you know, you said something in a private group, so it's not, you know, it's not protected, that's not true, right? I thought that was an important part of the discussion as well.
Yeah, maybe it's a different approach, but it's almost like you think about defamation. You can commit defamation if you tell one person something. You don't have to tell the whole world. You can tell one person. It could be defamation. Almost the same thing here. Free speech is you're communicating to someone. You don't have to be communicating to the entire world to have your First Amendment rights violated. You're having a communication, and that's really what's protected.
Yeah, so I think the lesson, obviously you do a really good, more extensive job for everybody, and they should be attending your social media class. The point here is look at your social media policies, right? If you were saying my social media policies are very narrow, as I think they should be, because it's not worth the lawsuit, right? Just, suck it up and have a little bit of thick skin here, which for some reason people don't want to do. So they, sue or whatever, or they discipline you. But it's one thing saying, look, you can't post hateful, harassing, bullying, and I should say sexually harassing, or, if you're prohibiting conduct that's otherwise legally prohibited, like sexual harassment and bullying and things like that, hey, that's all fine. Hate speech, is speech used to intimidate others. If you're trying to inciting violence, there's other recognized exceptions. Discord in the department thing, that creates disharmony and discord, etc. That's one thing. But when you have a catch-all like this, you have gone way too far. And in some sense, this decision isn't groundbreaking, but it's so well addressed that I hope people finally start looking at your social media policies. And I'll tell you what, do not use your normal municipal lawyer to do it, who doesn't follow this stuff. This is not a 5-minute conversation. This is sure as heck not the policy you copy from your human resource off the shelf book guide. This is a real policy, and the policy, and all I'm doing is promoting Kurt here, but the policy is one that comes with discussion and training. And isn't it funny? We do training on sexual harassment and workplace violence and all these things, but we don't train on not to discipline you about First Amendment rights, and we don't talk about your First Amendment rights because, God forbid, we want to tell people what your rights are in the workplace. But the leadership needs to be trained on this to understand you cannot retaliate against people, right, for their rightful expression of protected speech. And learning what protected speech is step number one before you write a policy. You can't do that from a off-the-shelf policy or one you copied from your neighboring department.
Yeah, there's a lot of bad policies out there. And I review them, and there's a lot of bad ones out there. So you really want to make sure that if you're going to use a policy, make sure that it complies with some of these decisions, whether it's the Petersburg decision, this decision. There's a number of other ones out there, but just don't assume that because even a big fire department or a big police department is using a policy, do not assume that it's where the language is where it needs to be.
Right. And this case, again, like I said, it's not groundbreaking, although I have a question for you, but it's not groundbreaking, but it's clearly very well stated. So some of our viewers also know Chip Comstock, and who is very well versed in these areas of law.
Taught me everything I know about the First Amendment. So
he said you taught him everything he knows. So but here's the thing: you all differ on the Pickering analysis, and I'm curious whose side, and you'll have to explain it a little bit to the viewers. But I'm curious, whose side did this case come down on? Your view or his view?
I think. I don't think we have a difference in the interpretation of it. I just have a higher level of frustration with the Pickering balancing test. To me, the first part of the Pickering balancing test is it a matter of public concern? Next is, did you say it as a private citizen? Okay. And we both agree that's fine. The next part is that you have to weigh the interests of the employee in saying it versus the interests of the employer in shutting them up. And I think that is an awful test. And Chip doesn't really have that. He says, we'll come up with a better one. And I said, well, that to me, just get rid of it, because you can't, how is a firefighter supposed to actually sit there and contemplate, well, my interest in saying this outweighs the fire department's interest in shutting me up. Therefore, I can say it. Therefore, I have protection. But what happens is once the firefighter posts it, a federal district court judge is going to be standing there saying, yeah, I think the fire department has a greater interest than that firefighter, or vice versa. And here's the other part, Brad. You can't incorporate that balancing test into policy language. If you try, it'll be unconstitutionally vague under the 14th Amendment.
Right, right.
And I've tried, trust me, I have tried to come up with language. You can't do it. And it just makes it worse. So if I was on the Supreme Court, we would get rid of the balancing part of the Pickering test. And that's where Chip and I disagree. And I think in hindsight, it's easy to apply the Pickering balancing test as it's written in hindsight. My concern is I want to keep firefighters and fire departments out of litigation beforehand. And even if the language is not a little bit more concrete, you can't even train your firefighters. Because what I tell them, I show them a couple of funny videos and a couple of things, and I said, I have no idea. I can't predict how a judge, and I use a baseball metaphor of close play at second base. So I'm like, I can't predict what the umpire is going to say when you get to second base. Let me know when you get there, because I can't predict what Therefore, play it safe, just like in baseball.
Is it worth it? Is it worth it?
Right, you're down a couple of runs. You're late in the game. Play it safe.
Have a thick skin, and if you want to respond to somebody by saying, listen, we heard their viewpoint, we disagree, in a tactful, polite, non-retaliatory, disciplinary way, then do so. But to just discipline somebody, you're taking a huge risk, and maybe big cities don't care, but small departments sure do. And by the way, let's be clear, because people may be saying, well, with regard to what the city of Chicago did, where the city's liable for insurance purposes, the defense of this case may be insurable. But if you lose, your department and not your insurance company is paying this money out. This could bankrupt a small department, a small agency. It's not worth it what you're doing to the agency. So take your personal motivation, the fact that you're personally upset and mad about what they said. Is it worth possibly bankrupting the corporation? Because these are non-insurable cases as far as if you lose, you got to pay out damages for them. So anyway, that's right. And I think that's all of them, right?
Yeah, we got a couple more and beyond the blog, but I think I got 7 of them. The Rialto, California just get hit with $100 million wrongful death lawsuit. Santa Rosa, I believe that's another California case. Oxnard, we got first three cases and beyond the blog are from California. Patient ejected from an ambulance lawsuit. Lawsuit, I don't think the fire department is involved in it, but just another lawsuit against the utility company for wildland fire in Washington State. And boy, the utility companies are taking a shellac in there on the West Coast in their role in starting or causing wildland fires. So, and often the fire departments, even after those lawsuits get going, the fire department will go in there and try to recoup some of their costs. So I'm not sure if that's in there as well, and a couple of other ones. But yeah, that's about it. Another lovely week in fire law world.
Yeah, it is. So. If people, I said it last time very emphatically, but I'll say it again. If you're not watching this, you are absolutely missing a chance, especially now with your social media policy. You have what I call kind of free insurance. You have a free chance to avoid so many issues. If you would go out right now, pull out your social media policy and see what it says. And watching these shows all the time, you have a chance to look at the conduct in your firehouse, right? And say if it's not acceptable. You get to learn from others' mistakes. Just like we learn from line of duty deaths and injuries, this is, you get to learn from others' stupidity or bad judgment, fine line sometimes. And you should be, watching and reviewing. And, so please share the link for this. Have other people read it, have your chiefs and your city managers. We're only on here for 30, 45 minutes a day. You can obviously go back and watch it. But if you can join us, you are getting such good, not because of us necessarily, because we're just saying what other people did.
The material writes itself. I mean, it's we don't have any creative part of this. This is just we're just reading the cases and the headlines, so it's easy.
We are.
Yeah. So, and also please subscribe. We're still, we broke 200 now. We're up to 215 subscribers. So please subscribe, keep us going. We need to get up to 400 to 500. And at 500, we're going to give away a copy of my book. So, you know,
and it's only been about 2 months. I mean,
So,
this is
yeah.
still pretty new. So we're doing pretty good.
Yeah.
This is getting some good traction.
Yeah.
But again, I think it saves you money. It will save you time and hassle to stay on top of it. And, you know, the last thing I'll say is when I lecture at the fire officer, or I teach the fire officer 3 course at the New York State Fire Academy, I said, you know, when you're hitting the chief's ranks, you need to turn your professional attention from, and I'm not saying ignore it, right? Not totally turn it, but you've probably have pretty good tactical and operational experience by the time you're a chief. What you need to do now is become a professional in the administrative world. And this is your course every day. You know, I hope you get drill credit for watching it or whatever, but this is what makes you a professional. Being able to say, I heard about this issue, I read on the issue, I listened to 2 attorneys talk about the issue, and now I'm going to go, you know, look at our own policies, procedures, et cetera, our own conduct in this case here. So you have a real chance to keep yourself professional. But this, I think, not trying to tout ourselves, and kudos to Kurt for coming up with this, but this really does that.
All right. And that's going to do it for another edition